Well, thank you everyone for being here. This is exciting, Calum. I'm going to do a case by case with live people watching us do a case by case.
And a bit of an odd one because it's a quick fire case update.
Yeah. So usually we read a case each independently, don't talk about it at all, and then just jump on the podcast, hit record, and talk about the case. And there have been some interesting ones this year, so we thought what we might do is just skip through some of them. We've got 7. I don't know if that's optimistic. We'll see how we crack on, and do a summary of the cases that we've been through. Yeah.
Pretty much all the English case law that you really need to know for 2023 so far, covered in hopefully around 45 minutes. That's the ambition.
That's the idea. Now, if you've listened to it, we kind of go through the facts and then analyse and chat about it and kind of go back and forth. So to try and keep this flowing and mix it up a bit, one of us is going to read out the facts and then the other one's going to have a bit of a chat about it.
And if anyone else wants to jump in and ask questions as well, then please just throw them out. There are some interesting cases that have gone through the courts this year, some kind of controversial ones. It was put to me by a client when I did this presentation a few days ago, that the High Court has really been specialising in large, well-funded finance banks and astronomically sized commodities traders basically going for try-on legal arguments to drag their opponents all the way through the court system, which they weren't very impressed by, being not a trade finance bank and not an astronomically sized commodities trader. But for lawyers in that space, it's very interesting because there are some really, really interesting decisions on some slightly out there points.
Yeah. Should I just hit this?
Okay. Yeah.
Okay. All right. So, first case that we're going to talk about is QUADRA Commodities and XL Insurance. This is a case that relates to the Agro Invest Group fraud back in 2019. I'm not sure if anyone came across that or had reason to look at it, but I like this case because it's an example of where English law has actually looked to US law, and a very old US law case, and said, this hasn't been decided in England. We're going to pluck a decision out of the US and we're going to apply it and make it English law, which, in some ways goes against the tide of English law being applied in US. This is going back the other way. So I think for this audience in particular, it's a nice one to open with.
And we'll come on to it, but there's a wrinkle to that as well.
Oh, okay. There's always a wrinkle. There's always a wrinkle. So QUADRA, the assured here, was a trader of agri-commodities. It had purchased goods in Ukraine from Agro Invest Group entities under a series of purchase contracts intended to provide pre-export finance to the Agro Invest Group. Now, by January 2019, QUADRA had entered into purchase contracts under which it had paid 80% of the price towards a number of cargoes that were stored at various storage locations inland in Ukraine. Now, in return for the payment of that 80% of the price, QUADRA obtained warehouse receipts for each purchase, confirming the agreed quantity of the cargo and the agreed quality of the cargo that was in storage. By February 2019, the Agro Invest Group fraud had come to light. It was out. And it affected several market participants. It was quite a big deal. The goods acquired by QUADRA had pretty much all but disappeared. They were gone. And the precise details of the fraud are unclear. But at some point, the quantities that were in the warehouse were not sufficient to fulfill the warehouse receipt quantity. Now, QUADRA advanced a claim under a marine cargo open cover insurance policy, and the insurers denied liability. QUADRA commenced proceedings in the English High Court and succeeded in its claims for indemnity and also for costs. The insurers then appealed to the Court of Appeal in England. So over to you, Calum.
So the Court of Appeal is faced with those facts, and they're essentially answering the question whether or not QUADRA has an insurable interest in the property that ceased to exist, such that XL Insurance Company had to pay out under this insurance policy. XL Insurance Company are saying there is no insurable interest because you cannot have an insurable interest over goods that aren't there. That's their first line of argument. And effectively, what happened here was your classic fraud, where somebody has X amount of something, and I'm sat there with X amount of grain. I sell the same amount of grain to Ed. I then sell the same to Joe. I then sell the same to other Joe, and all three of them have a claim on the one lot that I have, but I've sold it 3 times. So the first question, which was an evidential question, which really the High Court dealt with, there's a kind of procedural matter. It's quite difficult in the court system when you get past High Court level to really argue about fact. The Court of Appeal won't overrule the High Court on the factual finding, and the reason for that is that the Court of Appeal is a kind of more rarefied legal atmosphere. They're there to listen to legal argument, not to rehearse all the factual findings. So unless the Court of Appeal finds that the High Court judge made a massive error in the facts, then the Court of Appeal won't overturn that judge's decision. And here, the first question was basically, was that cargo ever there? Did QUADRA, I mean, even taking QUADRA out of the picture, QUADRA had warehouse receipts for a certain amount of goods. Did the goods ever exist? And the High Court judge found that they did. And the Court of Appeal judge found that the High Court had made a good decision on the evidence in front of it. And the High Court of Appeal doesn't need to do any more than that. The Court of Appeal says, we're satisfied that you looked into this properly and you came to a sensible finding. The Court of Appeal, in fact, does go further and says, not only that, but you came to the right finding, but they don't have to. So the second question is then, in those goods, did QUADRA have an insurable interest? And the issue here is that what QUADRA had was something that they'd made payment towards and that they've received a warehouse receipt for. But they hadn't received title to the goods, and they didn't have possession of the goods or ownership of the goods. And in fact, other people had taken possession of the goods under their own warehouse receipts before QUADRA had managed to get there. And the other issue, this is where the US case came in, was that what QUADRA had was an interest or a right or a warehouse receipt in respect of goods that were a small, unascertained part of a larger whole. And the argument from the insurance company was, well, unless you can tell me which of those goods yours are, then you can't have an insurable interest in them. And they ran this point as a matter of law. And this is where the Court of Appeal looked to the US courts, to a decision from the Supreme Court of Maine in the 1850s?
1874.
1874, the case of Cumberland Bone Company and Andes Insurance Co. And in that case, the Supreme Court of Maine held that you can have an insurable interest in property even if you can't identify precisely what that property is. So if you know that you have 5,000 tons of grain in a warehouse of 100,000, and you can't say that's my 5,000, but you know that 5 of that 100,000 is yours, then that can give you an insurable interest. And the Court of Appeal said, okay, we like that, we're going to adopt that as law in the UK too, that makes sense. The slight oddity is that there's this, the whole case is run on the presumption that that is not currently English law. And why that's strange is that if you go to the Cumberland Bone decision, the reason that the Supreme Court of Maine found that you could have an insurable interest in a small part of a larger whole was because they thought that's what the English courts did. So we have a bit of a kind of smoke and mirrors situation here. It's a bit circular. But I think everyone's probably come to the right decision unless you're an insurer. And the insurers did all come along and say, well, hang on a minute, if I've insured these guys to have some of the cargo, and my colleagues down the road have insured somebody else to have the same cargo and someone else, and then we're all going to have to be paying out in respect to these different people who are purporting to have an interest in this cargo, that seems unfair on the insurance industry as a whole, because you're going to have so many people paying out over the same cargo. To which the judge said, yes, but you've all been taking payments for your policies, so that's tough luck. And why this is kind of an interesting case is it's a good look at the requirements that you need to have an insurable interest. So what does it take to have an interest that you can insure under a contract of insurance under English law?
And on that, Calum, I think there's a nice little summary in the case where it says basically 4 things: a right that arises from a contract relating to the goods, so just a right; legal ownership or title; possession or the right of possession; or having made payment or part payment. Those factors would be enough to have an interest in the goods such that it is insurable.
Exactly. So I think we can park that one there. That's the key headline for this case, and we'll move on to the next one.
So the next one, we I think getting into perhaps a little more familiar territory for a lot of our audience. The UNICREDIT Bank and EURONAV case.
And this is the first of a nice trilogy of bills of lading cases from the Court of Appeal this year. I think maybe one was from the High Court, I'm not sure. I'll find out soon. Actually, this one. No, not this one. What you have to imagine here, I was hoping you wouldn't have to imagine, because I was hoping there would be a whiteboard, but you do have to imagine, because there isn't. Imagine a diagram, and at the top of the diagram you have EURONAV as the owners. And underneath EURONAV you have BP, who are the charterers of the SIENNA. BP enter into a sale agreement with Gulf Petrochem, and people may be familiar with Gulf Petrochem exploding recently, not exploding literally, going pop and becoming insolvent, which led to a wave of litigation, including this one. So BP are sitting underneath EURONAV, and BP sell a cargo to Gulf Petrochem. UNICREDIT, the claimant, are the trade finance bank. So UNICREDIT advanced the money to BP for the sale of the goods. BP then, the way the contract was structured is that initially BP held the bills, and BP were also charterers under a charter party with the owners. BP then passed the bills to the trade finance bank, to UNICREDIT, and the cargo is discharged under a letter of indemnity to Gulf. At the same time, the charter party is novated from BP to Gulf. So Gulf then sits as the charterer, the bills are held by UNICREDIT, and you have split up what was initially a fairly straightforward relationship where you had owners and charterers. Charterers were also cargo interests. Charterers held the bill, and owners had owners were the owners under a charter party, as were charterers. That will be flagging a lot of memories of the mere receipt rule for people familiar with shipping, which is this idea that in the hands of a shipper who is also a charterer, a bill of lading is only a receipt and doesn't contain or evidence the contract of carriage, because the charter party does that for them.
So do we all kind of know that principle? When the charterer who's holding the bill of lading, it's actually the charter party, which is the contract of carriage with the ship owners, not the bill of lading yet. It's only when that gets endorsed on that it then evidences or contains the contract of carriage.
And you can step back even further and say, typically what does a bill of lading do? It's a very special document. It's more than just a normal contract. Typically it's a document of title. It's also evidence of the contract of carriage, and it's also a receipt for goods. It has those 3 functions. But if you have this situation, as we have in our imagined diagram, at the very start, where you have EURONAV sat at the top, BP sat at the bottom under a charter party, and BP holding the bill of lading, then actually all the bill does is act as a receipt normally. Anyway, to continue with the facts, the Petrochem, having taken delivery of the goods, then become insolvent. Petrochem have taken delivery under a letter of indemnity. The bank tries to recover money under the letter of indemnity, but effectively the bank is sat there with only the bill of lading and no way to recover either the cargo, which has gone to Petrochem, Gulf Petrochem, or alternatively to recover any money because they've got an LOI against a company that no longer exists. So the bank then sues the owners of the ship. The bank says, you have given my cargo to somebody that you should not have done. And this leads to this decision.
Right, yeah. So it's, before I kind of get into the finding, it's interesting to think about these types of cases because letters of indemnity are so prevalent these days, and particularly in the oil trade, so is the concept of novating a charter party. And because it's done so regularly, I think players kind of don't necessarily think through what is happening to the traditional functions of a bill of lading and what's happening here. But once you start delivering against an LOI, you then have exposure, in theory, under the bill of lading for misdelivery. In this type of market, most of the players are very big companies, so the risk of not honouring an LOI is quite low, typically. Companies like Gulf do pop up and these kinds of things happen, but usually it's Shell and BP and majors and what have you. So the idea of delivering against an LOI is quite a common thing to do. And also this concept of novating a charter party. So the charter party just gets passed on to the next cargo interest in the chain without the typical way that happens through the bill of lading. And so the decision here, and the question was, when BP as a charterer/shipper is holding the bill of lading and they novate the charter party away, they're no longer the charterer, right? So they're no longer the charterer sitting there as charterer and bill of lading holder. And the question here was, is the novation, rather than an endorsement of the bill or anything else, is the novation away, converting BP into a non-charterer now, is that enough for the bill of lading to now spring up, be born, and become the contract of carriage between BP and the carrier? And the answer is yes, effectively. The difficulty here, and really I think the concerning issue here for banks is, or it's not just banks, but any holder in this kind of scenario, is that they lost on causation. So there was a finding of fact to say that if the ship owner had said to the cargo interest when they wanted to discharge the cargo against an LOI, they said, no, we're not going to do that, even though it wasn't the charter party. But let's say they said, no, we're going to wait for the original bills to come so we don't have this exposure to a misdelivery claim. The evidence and the finding of fact that the court had here was that the bank would have said, go ahead anyway. Even though they held the original bills, the factual finding was that the bank most likely would have said, go ahead and discharge. And the bank would not have insisted upon handing up of the bills for discharge and delivery to happen.
And the bizarre thing about this is that actually it's sort of the claim, the point at which the claim arises, there's an odd chronology here, which is that the cargo is discharged before the bank gets its hands on the bill. So the bank is bringing a claim against an owner in respect of a right that it says it has that did not exist either under the bill, because at that time the bill was simply a receipt. At the point of discharge, the bill is simply a receipt. Post-discharge, the charter party is novated, the bill comes into existence. The bill is handed to the Trade Finance Bank. The bank then says, actually, I had a right under this document that didn't exist at the time, or under this contract of carriage that didn't exist at the time, or wasn't evidenced in this document at the time. I had a right a few weeks ago, and that right is actionable. And the concerning thing for owners is that the court was with the bank there. The court said, actually, even though even though you didn't have a contract with the owners at the time, you still have a right to claim against the owners for what they did during a point of time where you didn't have a contract with them.
Yeah, exactly. But from a bank's perspective, I think this is I'd be concerned about this type of decision, frankly, because if you can lose on causation in this type of situation, and I'm not convinced this issue won't get appealed. I think there's a big debate to be had around the findings of causation. But what often happens in these types of cases is the principal issue is the one that's so hotly contested, and there's a lot of legal argument around this concept of novating the Charter Party and then the bill springing to life. That was what most of the argument was about. It wasn't really on causation, but causation is what saved the day in the end for the ship owner. And so from a bank's perspective, they've got to have policies in place, they've got to have a pattern of insisting upon delivery happening against original bills and be able to demonstrate that from a causation perspective. I'm not convinced by that, because I think a holder of a bill of lading shouldn't really be in the position of having to show that they would have asserted rights that they have under that document. It's a tricky, conceptually that's tricky for me to get my head around.
It's also tricky because of the chronological difficulties.
Yes.
It's very difficult to prove what you would have done in a situation that never happened. It's also odd, as a matter of law, that you have a right under a document that you didn't hold at the time, that later, you later find out that back then you had a right to do something. But it's even harder to say, without any knowledge of this right that I may one day have, that I actually currently have, but I don't know about until later, I need to do things now to prove what I would do if I had that right that I'm not going to know about until further down the line. So it's almost impossible for a bank to argue against this finding of causation, because they can't plan what they're going to do in advance of the thing happening. So as you say, it's policies, it's everything else, but a really kind of fascinating case and fraught with risk for everybody, I suspect.
Yeah, and there's also a big plug for electronic bills of lading.
Yes.
Different topic entirely.
Yeah.
Bit of a pet interest for some of us in the firm, but we'll come on to that another time.
Yeah.
Skipping on to the THORCO lineage. This is a case between Trafigura and TKK. Another English High Court decision. We're on package limitations here, so again, pretty familiar territory, I would dare say, for some of you. The claimant was Trafi. They were the owner of the cargo. It was loaded from Baltimore heading to Hobart under a bill of lading issued in Switzerland. Bill was subject to the Hague-Visby rules. And as many of you will know, Article Roman 4.5a of the Hague-Visby rules limits the carrier's liability for loss or damage to or in connection with the goods. And that's by reference to the hire of two alternative figures, either the 666 SDR per package or unit, or the 2 SDR per kilogram of gross weight of the goods lost or damaged, quote unquote, the goods lost or damaged. Now, whilst en route to the discharge port, the vessel lost power. It was an engine failure and grounded in French Polynesia. Salvors refloated the vessel, and they had a lien on the cargo in respect of the claimant's liability for salvage remuneration. In addition, a small part of the cargo was physically damaged in the refloating efforts. Is this a case? No, okay. I was getting grins as though this might be a case people know all too well. Anyway, a small part of the cargo was physically damaged. Okay, so that's only a small part of the overall cargo, quite important, causing losses of about $300,000. Now, Trafigura argued that the grounding had been caused by the carrier's breach of its seaworthiness obligations, claimed damages in respect of their payments to salvors and to the damage of the cargo, as well as on-shipment costs. And relying on the Limnos case, the carrier argued its liability for all the losses was limited by reference to the weight of the small quantity that was physically damaged, rather than the limitation being based on the whole cargo. And what was interesting procedurally about this case is that, and maybe some of you haven't seen this happen because this is a quirk of English law, but you can be in arbitration and decide amongst the parties to put a question of law under Section 45 of the Arbitration Act to the court, where you say, but there's some issue that you think, you know what, this is going to end up in the courts anyway, no matter what the arbitrators say. Rather than go through all the facts first and have them determined as well as the legal issue, we're going to agree amongst ourselves to put that legal issue by consent straight to the court under Section 45, and that's what happened here.
Yeah. So you have a situation where effectively there's a valuable cargo and a small amount of it is damaged, and the ship owner says, too bad, I have a nice limitation under the Hague-Visby rules. All I'm going to give you is the equivalent of 2 SDR per kilo of the damaged piece of the goods, and you then have a cargo claimant who says, no, actually the entirety of the cargo is damaged. And the entirety of the cargo is damaged, they said, because the salvors could exercise a lien over it. So they said that the existence of the lien, not what actually happened, simply the existence of the lien, constitutes damage to cargo. And the cargo is therefore damaged, and therefore the number that we are multiplying 2 SDR by, the per kilogram number of the goods, is all of the goods, not this small amount that were damaged. So that then explodes the claim, and they can comfortably cover all of their losses. And the owners presumably felt reasonably comfortable because there is High Court authority directly on this point saying that economic damage is not damage for the purposes of the Article 4 Rule 5 limitation. However, it was first instance decision of the High Court, and it was the only one, which means that it's open to challenge by the second High Court judge who comes along, and they can quite happily say, actually, that first judgment was wrong, which is what happens here. The judge said, no, that's not correct. Damage can include economic damage, and somebody having a lien right over your cargo is a form of economic damage, and therefore the goods damaged include include all of the cargo, because the lien right exists over the entirety of the cargo. There's a lot of this is a really long judgment, and the reason I think for the length of the judgment and the fact that they go through very in a lot of detail is that procedurally under English law, I'm not certain exactly how this works. It's one of the kind of finer details of English procedural law, but you have first instance High Court decision. The second judge that comes along can agree with it, and he can basically take it or leave it, or she can take it or leave it. When the third judge comes along, they have to, and if the second judge says, actually, I'm going a different way to the first judge, then the third judge can come along and has to follow the second judge, unless the third judge thinks that the second judge made their decision kind of without thinking about everything properly. So you then have this second judge coming along and saying, I'm going to disagree with the first judge, but I'm going to sew up the third judge. So number one makes the decision in the limnos and says, goods lost or damaged does not include economic damage. Second judge comes along in this case and says, I think that's wrong, and I want to make sure that when the third judge has to deal with this in 200 years, they have to look at my judgment and they have to say, not only do they disagree with it, but I got to this judgment without thinking about all the facts. So the judge has a kind of 20, 30-page analysis of the history of the Hague-Visby rules, looking through the negotiations when the Hague-Visby rules were being prepared, looking through all the different cases on these points to completely sew up the idea that they didn't properly understand what they were talking about, and therefore this becomes pretty settled law. In my probably the right law as well. It's odd to say that damage can only be physical, particularly when, as the judge did, you start reading every single dictionary definition of the word damaged and find that almost all of them include but don't limit damage to physical damage. It suggests that there are other forms of damage, and somebody else exercising a right over your goods probably constitutes damage too.
Yeah, but I suppose it's also good for carriers because there is now a finding that claims for economic loss only will still be limited.
Yeah, so under the previous decision, you had this weird situation where if you're a carrier, what you really want is a little bit of cargo damage. If there's none, then if there's no cargo damage at all and no physical cargo damage at all, then it's open season for the claimant. You have no limitation at all because there's no damage against which to measure your limitation. If you have a tiny little bit of physical cargo damage, then you can say, okay, I've got cargo damage. So your claim is limited to that amount multiplied by, that weight multiplied by 2. Whereas this probably makes a bit more sense, because it says either if the whole of the goods are damaged by some economic damage, then the limitation goes all the way through. But if they're not, then they're not.
So next
up.
Our next one is one of our favourites, a 1 year Hague-Visby rule, well, Hague versus Hague-Visby rule 1 year time bar case. And what are the differences between Hague rules and Hague-Visby rules on particular types of claims, misdelivery claims arising post-discharge?
Yeah, so the claimant is FIMBANK, and FIMBANK were the holder, as a trade finance bank again, of 13 bills of lading covering a cargo of coal which was shipped on board the giant Ace, owned by KHC Shipping. Actually not owned, I think demise chartered, but either way they were issuing the bills. The bills incorporated the Hague-Visby rules, crucially, which included the time bar in Article 3, Rule 6, which limits all claims after 1 year, after 1 year from delivery. There was the discharge and delivery happened in April 2018, but they didn't happen at the same time. And another kind of important elementary point is that discharge and delivery are two separate things under English law. Discharge is physically taking something off a ship. Delivery is giving something to somebody. Often, that will happen at the same time, because you will take something off a ship into somebody else's possession, and you will be discharging as you deliver it to them. But that's not necessarily always the case, and actually in many circumstances it's not the case, because often, for example, with a grain cargo, you would put your grains into some kind of customs bonded warehouse, and the goods would not be delivered to the consignee until some point after they'd been discharged. That's what happens here, and there's then a period of more than a year after discharge. If you have discharge, then you have delivery, then you have a period of 2 years, and then the claim is brought by FIMBANK under the bills, saying you misdelivered, you delivered to the wrong person, you should have delivered to me, I was holding the bills, you've converted that cargo, and therefore you owe me the value of it. The carrier said, so the carrier, KCH Shipping, their defense was, your claim is time barred. We have the Hague-Visby rule time bar of 1 year after delivery, and your claim is therefore time barred. FIMBANK said, no, my claim is not time barred, because the Hague-Visby rules only apply to the period of ocean carriage. And the period of ocean carriage ends on discharge. And the Hague rules and Hague-Visby rules are very clear on that. And they said if the application of the Hague rules ends on discharge, then you can't rely on a time bar in the Hague-Visby rules for something that happened after the Hague-Visby rules ceased to apply. And the arbitrators said, you are wrong, and the High Court said, you are wrong, and then it went to the Court of Appeal, who said,
you are wrong.
You're wrong.
So, yeah, basically, there's a big difference between the relevant provisions in the Hague-Visby rule and the Hague rules. And this was all about construing an international convention and what the drafters of the convention actually meant by an amendment in the Visby amendments to the Hague rules. And the important rule here is, of course, Article 3, Rule 6. I'll just read to you the Hague rules wording first. Sorry, I don't have it up for you to follow on, but there's a key change in this, and I'll kind of emphasise it to you. The carrier and the ship shall be discharged from all liability in respect of loss or damage. All liability in respect of loss or damage, unless suit is brought within 1 year after delivery of the goods or the date when the goods should have been delivered. So it's this language, all liability in respect of loss or damage. When we go to the Hague-Visby rules, the same provision, Article 3, Rule 6, instead of providing that language, all liability in respect of loss or damage, the new rule provides for discharge from all liability whatsoever in respect of the goods. So you can see it's a much broader concept, right? And this was a deliberate amendment that was brought in the Visby amendments. And so the court held that the Hague rules and the wording that was in the Hague rules was limited to the period of responsibility under the Hague rules. So from loading to discharge. That was its period of responsibility, so that was its application for the language that it was in the Article 3, Rule 6 clause. However, that whatsoever in respect of the goods language was found to be sufficient to make this wider. And so it could apply to claims that would arise after discharge, which is what this was, a misdelivery claim arising after discharge. And the court went through a number of ways to get to that, and importantly, they looked at the travaux préparatoire. I haven't said that. You want to have a better go, Joe? Travaux préparatoire. Is that better? Kind of. Oh, there you go. Thank you. All right. Aussie accent and all. Basically, the preliminary materials that set out some of the discussion and what the drafters were debating and the questions that went to the committees in formulating the convention. This body of work can be looked at in construing an international convention. It's not decisive. It can be persuasive, and there are a lot of warnings about looking at it too much, because obviously international conventions are hotly debated, and just because someone's coming along saying this is what the amendment should be doesn't necessarily mean that is what the amendment ended up being. But it does help in knowing what the discussion was about. So if you can look at them and say, well, this was an issue that was being debated. One of the questions was, should this clause have application for all types of cargo claims, irrespective of when the period of responsibility is? If the outcome of that discussion is the language that you see in the convention, which is clearly much broader, then it's kind of obvious that one side of that debate has won out. And we've debated this amongst ourselves. We're not sure that it's as clear. The court actually describes it as a bullseye find. And we're not sure that it's as on point as it's stated in the judgment.
So the law, when you look at these documents that are generated in the negotiations for an international convention, is that if you have what they call a bullseye, or what some judges at some point in history has called a bullseye, then you can say, okay, that's, they're talking about this specific thing, and they're saying they're introducing this amendment to deal with this specific thing, so we can assume that this amendment means what they intended it to mean. If you don't have a bullseye, i.e. if you're somewhere around, the green ring around the edge of the bullseye, then you can't use it, you can't rely on it, because then they take the view that, well, there might have been a few parties who strongly disagreed, but they thought, okay, that's not quite the point I disagree on, so we'll let it slide. Or they wanted to win somewhere else, so they didn't waste their energy fighting a point they were going to lose. Whatever it is, you have to be very cautious, and it has to be a direct hit. Here, the negotiations for the Hague-Visby rules were, they arrived with the Hague rules, and the Hague rules, as Luke said, the Hague rules say that you be discharged from all liability in respect of loss or damage. And the committee said, okay, but does that cover misdelivery? And there was some disagreement. Some courts have said yes, some courts have said no. The English court said yes. And so they said, okay, well, should we be covering misdelivery? And there was this idea floated that you should have a two-year time bar for misdelivery claims, and your normal 1 year time bar for cargo damage claims. And that was rejected. They said, let's not split them up. But what we do want to do is we want to make sure this does cover misdelivery. And so to ensure that the wording definitely covered misdelivery, which was already the English court's position on the Hague rules, they included this all liability whatsoever. And what the English court has taken that to mean is that there was some intention to increase the scope of what it covers. But actually, in my view, the English court had already given had already given effect to the clarificatory change that was later made. There were these two competing interpretations: either it does or it doesn't include misdelivery. Some people said it did, some people said it didn't. The English court said it did. They then make it clear that it does, and the English court says, you must be doing more than just making it refer to misdelivery. Not necessarily, you might just be clarifying that the English court had it right all along. And therefore, I don't think it's necessarily a total bullseye to say that the intention of the Hague-Visby rules in expanding the wording of the time bar was to say that any claim for misdelivery, even where you're past the period in which the Hague or Hague-Visby rules would normally apply, because you're past that period of the ocean carriage, should fall under the new regime. My view is that probably the Hague Rules and the Hague Vistry Rules should have the same effect either way. If the English court's view is that the Hague Rules are wide enough to cover misdelivery, then I don't really see why they wouldn't be wide enough to cover misdelivery after discharge. And if the Hague Vistry Rules are similarly wide enough to cover misdelivery, I don't see why they would be the only one that covers misdelivery after discharge. So I find it's a little bit odd to split the two, and I wasn't convinced the admittedly limited amount of reading, which was nothing compared to what the Court of Appeal will have done on this topic. But I wasn't convinced that in the reading that I've done on it that the intention of the Hague Vistry Rule amendment was to create such a dichotomy between the two regimes in terms of the extension of time for the application of the time bar.
Yeah. Yeah, it's an interesting one. And there's a court that's gone the other way. Was it Hong Kong? Hong Kong? A court has gone the other way on this.
Yeah.
And I'm with you on this. I think it's, whilst it's very broad language and use of whatsoever, we all know if you see whatsoever in a clause, wow, it can include everything. But that's different to extending the period of responsibility or the period of application, if you like. Is this clause good enough to extend the application of what it's supposed to be applying to? I don't know. Anyway, we could go on.
I think probably the answer is that the Hague Rules have the same effect.
Right.
And it's artificial to reduce the period of applicability of the Hague Rules. But yeah, anyway,
interesting.
We are running out of time, so we may have to skip a couple of these.
Yeah,
cases.
that's a fair point.
We want to skip, I would say.
Okay, well, let's jump on to
Eternal Bliss.
Eternal Bliss.
Pretty quickly.
Yeah, let's do that quickly. We've actually spoken about Eternal Bliss to the SMA. We was it episode 23? I think it was. I looked. So yeah, we've been on this before, but what's interesting is it's settled. So and that's why it's managed to fall into our first half of 2023 cases, even though it's an older decision. We were hoping to have this go up to the Supreme Court. They got permission to appeal. It was in the process, in the court process for the Supreme Court. I actually, last year, some of you I know will know this, but I taught a university course in Australia and kind of set up this course for the first time on shipping and commodities law. And the problem question that we set the students was on the eternal bliss. So we made them kind of argue one side or argue the other side. And, it was set up because I was thinking, I'm going to do this course again this year and we'll have a Supreme Court decision to show who got it right, But alas, we don't. We're stuck with the Court of Appeal decision. Yeah,
the entire shipping legal community celebrates in the settlement of the eternal bliss and the withdrawal of the claim.
Do we though, in terms of where the law is now? That's the question, right?
So it's an interesting one, which means we now have the Court of Appeal decision standing as law on this point. The question was, so under English law, and I'm actually not sure this is the same under US law. Under English law, if you fail to load or discharge within the lay time, that's a breach, and the damages that you recover for the breach of that failure is demurrage. So demurrage is the liquidated damages regime in response to the breach, which is failing to load within the lay time. If there are two breaches that happen at the same time, and one of them is your failure to load or discharge within the lay time, and another one is something else that causes damage to cargo, then quite straightforwardly you can recover your damages for delay under you can recover your demurrage plus your cargo losses under the second claim that you bring. The eternal bliss is a interesting one, because the damage the damage caused by the failure to load, or I think in this case discharge within the lay time, was not only the loss of use of the ship, it was also damage to cargo, which became extremely mouldy. Probably there would have been a defence under the bill, but I think this happened in a jurisdiction where those kind of defences are not particularly recognised, and the local court went ahead and made a decision. Or was it settled? I'm trying to remember. I think it was settled.
I think carriers settled with cargo and then looked down, right?
Yeah, I think it was settled I think there was some duress from the local court. It was one of those where it was not entirely clean cut, but they were trying to pass these losses down to their charterer, saying you're responsible for discharging within the lay time. You failed. That's a breach. We get our demurrage from you for our loss of use of the ship across that period. But that breach also caused us this loss, which was having to settle a cargo claim. And the court looked in detail, under actually the same process, was this another Section 45 reference. So the parties agreed, no one's ever dealt with this question before, let's send it to the court. And the court said, okay, we'll take a look, and had to answer the question of whether demurrage is a liquidated damages for your loss of use of the ship, or liquidated damages for all consequences of delay.
And Lord Justice Mayall's leading decision on this, the Court of Appeal, reversed the decision of the first instance court, and essentially found that demurrage liquidates everything, all types of loss. And that is the law now. That is as things stand. So it doesn't matter if it's a cargo loss, as it was here. It doesn't matter if it's related to the loss of use of the time, which is what we probably think of demurrage, as an instinctive matter, covers. And it's often calculated based on what the hire rate should be, or something similar to that in a forward-looking way. But here you can have demurrage liquidating a cargo loss. So it'll be interesting to see whether that kind of gets priced into demurrage clauses moving forward. I'm interested in other people's views on this or experience, but I haven't seen this kind of fact pattern. In my time at the club, time private practice, there are a lot of unusual facts here that I'm like, how often would this arise where you don't have a separate breach? You only have the breach of using too much lay time. That's just sole breach, and it ends up cargo damage. So I don't know. It's not something that we would tend to see too often without some other separate breach to claim.
And you see this sometimes with cases that you read and you get quite excited about, and you think this is a really interesting principle that's bound to come up all the time, and somehow it's never been touched by the courts. And then you sit and think about it and you go, hang on, why has it never been touched by the courts?
It's not likely to happen.
It really doesn't happen very often. So, But I guess one of the main points for members, if you're an insurer or if you're a charter and the charter parties, is you can. This is all just a matter of contract. This is all subject to a contraindication in the charter party. So you can say demurrage, open brackets, for loss of use, close brackets, and then put the rate in if you want to expand it.
And the case citation.
And the case citation, yeah, exactly. But I think that's probably all we need to say.
I think so. The only other point I was going to make on this is that we had leading commentators like the Voyage Charters book and Scruton going complete different directions on this. So this has been debated for 100 years. So it is kind of why we were hoping it went all the way. It's been a hotly contested dispute because it's everyone. It's one of those weird words that if you're not in shipping, you don't have any idea probably even how to spell demurrage, right? Then you hear about this word day one, and you're like, okay, now I know what demurrage is, but do we really know what it covers? That's why it's, I don't know, it's a really interesting kind of case for that reason.
I think that's why it was interesting, because you're right, it just made you think, actually, what this concept we're all so happy with and so familiar with, none of us know what it means. I guess now we do. The last one that we had, which we can actually cover really quickly, because we are now at 4 p.m, I can probably cover this in about 30 seconds. You can
do this.
Yeah. This was one where I was stunned that they managed to get an appeal off the grounds. Normally getting an appeal from an arbitration award in the English courts is quite tricky. Historically, it's been a success rate of about 10% getting through the Section 69 hurdles, which you have to prove that the decision was obviously wrong, or it was open to serious doubts and on a point of public importance. That's typically very hard. In this case, there was a charterer who withheld hire, who made deductions from hire that were not agreed by owners. There was a clause in the charter party that said, notwithstanding of the terms and provisions hereof, no deductions from hire may be made for any reason under clause 17 or otherwise, whether or alleged off-hire, underperformance, overconsumption, or any other cause whatsoever, without the express written agreement of owners. Then said deduction from the hire are never allowed. And the charterer, who had deducted from hire, without the express agreement of the owners, said, I didn't deduct from hire. I simply didn't pay you something you were never entitled to. There was no hire to deduct from, and therefore I'm not captured by this clause because this is talking about deduction from hire, and if no hire is payable at all, then I can't have deducted from it. The tribunal said nope, and the High Court pretty emphatically said no too. I'd be stunned if this goes any higher, but it's an interesting indication to me of the fact that there is probably more scope now for a Section 69 appeal getting through than there was a few years ago. If you have an award that's gone you think the wrong way, then this suggests to me that the High Court is maybe having a little bit more oversight of arbitration, particularly maybe in the shipping industry. And also, I suppose, if you're an owner, these kind of clauses will be given effect to, not that there was any reason why they would not be. Anything else?
I think the only, I'm trying to take something else away from the case. I think the other point I'd make here is that, and I'm sure we've all either been in this position with clients or, you know, yourselves, is sometimes parties are too quick to deduct hire or withhold hire when they're not contractually entitled to do so, and just hold on to the money, stay in the money. It can lead to problems.
Yeah.
That's probably all I'm going to say today, but
yeah,
it can do. I know it's a stay in the money. It's one of those golden rules, but it can open up complications. It really can.
And I don't know the exact facts on this one. It was a while since I read it, but if you were in a situation, for example, where there was a deduction made and then the owners withdrew the ship and then charterers lost out on a higher rate that was otherwise reasonably attractive and had to pay a lot more to charter back into the market, and if this claim were about wrongful withdrawal and they were saying actually owners were not entitled to take that ship out of the service because we paid hire in full, then you could be looking at a really significant loss out of a, in my view, pretty clear error in not paying hire. So you have to be very careful about hire and payment of hire, and almost any opportunity that a commercial judge is given, they will say that hire is the lifeblood of a ship owner, and that it's extremely important that charter pays hire at all times. Yeah,
and look at anti-tech clauses and all the rest. There's a whole world to explore. Then, look, I think that's probably enough. I know we had another one, but 6 out of 7 wasn't too bad.
That's pretty good.
Thank you everyone for listening in. We hope you've enjoyed our live version of Case by Case. Oh, we got a question. Yeah,
I missed the first 60 seconds. I apologize. Have you guys ever thought about doing a podcast?
Yeah, there's an idea. So yeah, any before we wrap up, any questions on any of the cases? I know we've gotten through a lot today, so thank you for coming along. Thank you for listening. Yeah.